आगे मेरे तो आ गया मैडम दोबारा स्टार्ट।
Assalamu alaikum and a very good morning. First of all, I would like to apologize that we are starting the webinar slightly late due to some IT issues.
मैंने यहाँ से बंद किया वरना इको होगा।
So, Fawzia, could you please to your side on mute so that we can start it? I think we should start it now. We have around.
इमरान साहब पहले हम शेयर कर लेते हैं, टेस्ट कर लेते हैं शेयरिंग ऑफ प्रेजेंटेशन।
Yes, yes.
आई होप हम लाइव नहीं हैं अभी।
म्यूट पे हैं।
Yes, I can see your screen.
सर विजिबल है प्रेजेंटेशन?
Yes, yes, it is visible.
इसको फुल स्क्रीन कर लीजिए।
ठीक है, अभी मैं कर लेती हूँ। ठीक है सर, चला सी।
Am I audible?
अनम्यूट करके ना अपने इससे रिकॉर्ड को आप म्यूट करो।
सिग्नल ठीक है भाई।
Imran sir, good to go from our side.
Yeah, so am I audible? You have been
Yes,
able
you
to.
are.
Okay. So, Assalamu alaikum and a very good morning. We welcome our members and participants to this webinar on proposed amendments to the Companies Act 2017. The purpose of the webinar is to provide an update on the proposed amendments to the Companies Act, which SECP published through its concept paper in mid-January 2026, and have our members' feedback on them. So we have with us a distinguished team from SECP, and from the team, Mr. Muzaffar, Mr. Shahzad Afzal Khan will be explaining, proposed amendments, taking your questions and answering them. So first of all, I would like to invite Mr. Mohammad Mirza, Distinguished Commissioner from SECP, to give his opening remarks. Mr. Mirza is a legal professional with nearly 24 years of experience. He's an advocate of the Supreme Court of Pakistan, and he has been involved in many regulatory changes that have been brought in by the SECP. So over to Muzaffar Saab to give his opening remarks.
So, Mr. Mubashir says the executive director will open the session. Mrs. Saab has not been able to join yet till now, so it is requested that the executive director may please open the session.
Yeah, please.
Join.
So the Saab, could you please give your opening remarks? Since the Commissioner Saab is not here, so I would like you to give opening remarks on the proposed amendments to the Companies Act.
So, should I start, Imran Sahab?
Yes.
So, Distinguished Vice President, ICAP, respected participants, colleagues from the corporate sector. Assalamu alaikum and a very good morning. At the outset, I would like to sincerely thank the Institute of Chartered Accountants of Pakistan for providing this distinguished forum for today's consultative session on the proposed amendments to the Companies Act 2017. As the premier professional body representing the auditing and accounting profession in Pakistan, ICAP plays a vital role in strengthening financial reporting, audit quality, and corporate governance, and we deeply value its continued collaboration and constructive engagement in regulatory reforms. Allow me to briefly share the journey of these proposed amendments. The reform process was initiated when the Honorable Prime Minister of Pakistan constituted the Cabinet Committee on Regulatory Reforms, the CCOR, in September 2024 under the leadership of Minister for Investment and Chairman BOI, Board of Investment. So subsequently in July 2025, the CCOR constituted a dedicated subcommittee under the chairmanship of SAPM on Industries and Production, which was specifically tasked to review, analyze, and recommend reforms in the Companies Act 2017 and represent its recommendation to the CCOR for consideration. This structure and consultative mechanism laid the foundation for the reform proposal that we are before you today. Presently, the Board of Investment share three comprehensive reform packages. Number one, the ultra fast-track regulatory reform package, the regulatory reforms package for unlisted companies, and the regulatory reform package for listed companies. The proposed amendments are focused on four areas. The four major areas are: number one, promoting ease of doing business. Number two is encouraging digitization and decriminalization of penalties and strengthening the principles of corporate governance. So the changes are revolving around these four broad areas. The Securities and Exchange Commission of Pakistan has recently been recognized as a reform champion by the Honorable Prime Minister of Pakistan during the launch of National Regulatory Reforms Initiative. This recognition reflects SECP's sustained commitment to improving ease of doing business, advancing digital transformation, and fostering a modern, facilitative, and compliance-oriented corporate regulatory framework. As Pakistan's corporate governance continues to evolve and integrate with global market, our legislative framework must remain dynamic and forward-looking. The Companies Act 2017 laid a foundation, and these proposed amendments are intended to build upon that foundation and ensure that it continues to support sustainable economic growth and enhance Pakistan's global competitiveness. So today's consultation at the esteemed forum of ICAP is an important part of that reform journey. Your insight and practical experience will help ensure that the final framework is balanced, implementable, and aligned with the stakeholders' needs. So we look forward from the SECP side to your valuable feedback and a constructive discussion. Thank you. Imran Saab, over to you.
Thank you, Mubashir, for your opening remarks. So now I would like to invite Mr. Shahzad Afzal Khan, Director, SECP, to give a presentation on proposed amendments to the Companies Act. Mr. Shahzad is a proud recipient of Pakistan's prestigious civil award, Tamgha-e-Imtiyaz, for his services in AML and removal of Pakistan from Financial Action Task Force grey list. He has over 25 years of extensive experience in the field of corporate finance, development, and enforcement of corporate laws and allied regulations. So over to Shahzad.
Thank you, Imran Saab. Thank you very much for a gracious introduction. Thank you, ICAP, for providing us with this opportunity to present the proposed amendments of Companies Act to the August audience. Also, a very big thank to Janzeb Amin Saab, who has been really instrumental in the earlier discussions and holding for this session. So I start with the gratitude to the Institute of Chartered Accountants of Pakistan. We will just be sharing the presentation. Is this presentation can be viewed on the screen, Imran Saab?
Yes, we can.
And I remain audible, sir?
Yeah, you are audible, yes.
Thank you so much. Thank you so much. So the presentation will revolve around, next slide, please. The background, the interplay with the Board of Investment, the theme of the proposed amendments and major proposed amendments will be discussed during our discussions. Whatever you think, you can anybody can ask any question regarding any part of the concept paper, be it is in the concept paper or otherwise you want to highlight something that would be really beneficial. It will be a mutual understanding session where and I would like it to remain as interactive as possible so that we can learn from you and take away the objective of the session is to take the suggestions from the participants and to further improve the document. The as Mubashir Saab has just highlighted that the Prime Minister constituted a cabinet committee on regulatory reform in September 2024, and the work starts from there. The constitution of the committee was Minister for Investment, that is the Chairman BOI, Minister for Commerce, SAPM on Industries and Production, and the Cabinet Committee on Reform may co-opt any other member as required. The CCOR constituted on 9 July a subcommittee under the chair of the SAPM on the industries and production, having representation from, and then the committee was constituted in the form that BOI was there, SECP, Ministry of Finance, State Bank of Pakistan, FBI, FBR, OICCI, and co-op many other members, just to have a holistic view of the changes which are intended to be done in the Companies Act. The subcommittee was tasked to review, analyze, and recommend reform in Companies Act for unlisted company and present them to CCR for their consideration. Next slide. But the work spread on three piece of documents shared by a Board of Investment. The first one was BOI's ultra fast track package. They proposed only 5 provision in that package, but SECP was already working in house on the amendments. So we then introduced a draft bill with on 24th July 2025, and there were 49 proposed amendments were there, which were approved by CCOR. Then the BOI regulatory reform submitted a package which is called Package 01, and it was based on only for the unlisted companies. The benchmark countries in this package was UK, Canada, and a state of USA, which is Delaware, which is considered to be a very conducive to the business environment in terms of regulatory regime is concerned. So they wanted, the theme was to modernize the law with global best practice, and the package was focused on only on private companies. Then there was another package for the listed companies. The benchmark here was UK, USA, Hong Kong, Singapore, and India as well. And the package was targeting towards reducing compliance for the listed companies. So these were the three packages which were shared by them. They studied all the provisions and suggested changes and few elimination in others, and also required us to retain many provisions which were already there and introduced in the Companies Act of 2017. Next slide, please. So the outcome of this is the total amendments of 183 provisions. These 183 provisions were revolving around major categories, and these categories include ease of doing business, regulatory oversight and corporate governance, digitalization, and decriminalization. In terms of ease of doing business, 114 provisions have been introduced, and there has been amendment in 114 provisions. In terms of regulatory oversight and corporate governance, 34 provisions have been amended to this extent. In terms of digitalization, 17 provisions have been amended to achieve this objective. And in and the theory of decriminalization came from the idea of the Decriminalization Amendment Act of India in 2020, where they have decriminalized the provision, meaning by the penalty provision is commensurating with the default. And these decriminalization provisions were actually not in use by SECP at all times. For example, under Section 220, non-preparation of books of account carries the penalty of a criminal penalty. But there are circumstances where only a monetary penalty can do justice and commensurate with the default. There are many other provision of these sorts, and 18 provisions have been decriminalized and have been changed from the criminal penalty to the monetary penalty or administrative measures. Next slide, please. Now, I would switch to the major proposed amendment. Our focus was to make the business easy, and there were many provisions where commission or registrar approval was required. The few which have been eliminated and causing hindrance to the quick decision making of the businesses were the issuance of share by otherwise than right. Section 83 has been amended. No approval is now required. Shares at discount. Only special resolutions can do the magic, and only filings can be brought to the registry. But such approvals from the commission has been eliminated. Appointment of sole agent has also been done away with. Conversion of company status from private to other form of companies has also been introduced, that there is no requirement of commission approval or registrar approval there. Similarly, for change of name, the approval of the commission has been eliminated. It will simply be filing now. Of course, the name reservation will still will be required, and availability of name has to be taken by the company if they want to change the name. Once it is there, the change of name is there, then subsequent changes in the memorandum articles or the constitutive documents then require another layer of approval from the concerned registrar. That requirement has been eliminated. Similarly, in terms of reduction of capital, the power was with the court. Only with the court approval, these reductions were supposed to occur. The amendment has been brought in to remove this approval of the court. The annual general meeting and EOGM is exempted where the board of director represent 75% voting right. For this is only for the private companies, and they may pass resolution in BOD meetings. Uh, when we have been doing all these adjudication for non-holding of AGMs or certain provisions where the matters which require special resolution of the companies, but the board already had this kind of voting majority within themselves. So it becomes then a futile exercise. The board is there, the member of the board already hold this kind of meeting, and still they are required to conduct issue notices for 21 days, and then other requirements have to be complied with in respect of general meetings or annual general meeting. So if the board is representing on the 75% of voting rights, then the need of holding such meeting has been done away. A proviso has been added in the relevant section, which is 132 and 133. Next, please. So the in terms of digitalization, it has been now allowed to hold the general meetings virtually or both ways. They can also hold it in physical form. Then the e-meeting and e-voting has been made mandatory from the date notified by the commission. This notification will also contain the manner in which such e-voting and e-meeting can be conducted. This has been envisaged, and as you know, for listed company, the regime is already there. For the rest of the companies, the regime will be introduced if subject to passing of the law. Statutory meeting and commencement of business provision is eliminated. The only purpose of the statutory meeting, and especially the section 19, was targeting that whether the subscriber have deposited the amounts with the company, and shares have been issued accordingly. Now, in Companies Act of 2017, Section 17 was also introduced for all type of companies, not only for the public companies. So this section actually become redundant by virtue of presence of Section 17. So the concept became obsolete, both in terms of statutory meeting and in terms of the Section 19 for commencement of business provision. So these both provisions have also been eliminated. One of the major change is that we are reducing the constitutive documents from two to one. At present, we have two constitutive documents. One is the Memorandum of Association, the other is the Articles of Association. Both these provisions, both these carries their own kind of requirements, but the new Article of Association will carry the elements which are currently placed in Memorandum of Association. This will help in subsequent changes to be made by the companies. Instead of making two changes in the documents, the companies will only be going through only one change. So the single constitutive document will dictate the bylaws of the companies, which will be the Articles of Association. And by virtue of this change, there are many consequential changes which requires elimination of word Memorandum of Association. We have tried our best to put it in the draft bill wherever it is possible and where we could find the change. And we have also catered that if there is any reference to the Memorandum of Association, that reference is now meant to be towards the Article of Association. So these changes have been made. Requirement for publication of notice and official gazette to struck off the company is eliminated. Now, see, our target was to make the entry easy. The entry of the company is easy. In that term, we are targeting towards the. We will just discuss our principal line is to be eliminated and is to be only restricted to principal sector, and we are reducing two constitutive document to one document. So these changes will make things easy for the entry in the business as a uh, company. Now, the other target was to make the exit also easy. So, in terms of Section 425 and 426, if companies have no asset and liability, there was a cumbersome process of issuing notices and then publicizing these notices in the official gazette, which actually took huge effort and a lot of time to get them printed in the official gazettes. So these have been eliminated. That official gazettes will be replaced by a newspaper ad to make the public aware that these companies are closing and going and are being struck off from the register. So in both ways, either it's on the basis of application or on the motion of the registrar, the elimination of the companies will not be required anymore to be published in the official gazette, but only in the newspapers, which will make the process swift and easy, and such strike off will be done in shorter period of time. Similarly, if the first director will continue till there is any change in members of the company, that is the mandatory requirement of holding first election of director is eliminated. If there is no change in the members, the you have provided your information in form 1 that these are the directors, and then there is no subsequent change in the shareholding, that will not be required anymore unless a company wants that to have certain time period or duration for holding the directors election, they can have that in their articles of association, and time period can be enumerated there. But not the law will not dictate the business what to do. Similarly, in the election of director is exempted in case of a single member company, and if all members are directors in a private company. So the section 158 for election of director is also eliminated if all members, if there are two shareholders and both shareholders are on the board of director, there is no need of undertaking fresh election after the period. The period can be mentioned, however, in the articles, and 162 will always be there. If there is any change in the shareholder, then fresh elections can be held, uh, and new board can come up. So these are the kinds of things which will make things easy for the businesses instead of uh, lingering these long. Uh, since the digitization has been an integral part of the Companies Act, the electronic proxy concept has been introduced, and similarly, the time period for submission of such proxies has also been will be prescribed. It will be notified and will be reduced from 48 hours because of the swift provision of the proxies through electronic process. We have the concept of special audit was there in Companies Ordinance 1984. This concept has been reintroduced in this amendment, and but there's slight change of threshold, which was 20% earlier. Now it is 10%, and there are other few provisos introduced in this section. The concept of revision of the financial statement has been brought in. Uh, 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 it has been taken from the Companies Act of India of 2013, where the if the director feels that there is change in the financial statements are not in compliance with the requirement of the act, then they can revise it in a financial year, but they cannot revise it over the period of 3 years. And also, they cannot revise it twice. Only one revision is allowed, and they can do it. In case of listed company, such revision is only allowed if commission provides such approval to the company. Similarly, the exemption of the filing of annual return is eliminated from section 130. It is up to the paid up capital of 3 million. The companies are not required to file any annual return, but considering the outcomes and recent cases, it has we have eliminated the exemption, and it will be now annual return is required to be submitted by the companies. Similarly, the exemption in filing of audited financial, which is 10 million, a paid up capital of 10 million rupees, has also been amended to the extent that the thresholds will be notified by the commission. So these thresholds will be holistic based on different criteria, not only the paid up capital. This has been an earlier observation as well by the Institute of Chartered Accountants of Pakistan as well, when the promulgation of Companies Act 2017 was done. That the only criteria of paid up capital is not good enough to decide on elimination or exemption of any kind of company. So it will be more holistic based on different parameters like assets of the companies, like turnover of the company, or pay or number of employees, and obviously on the paid up capital of the company. Similarly, the audit exemption thresholds will also be notified by the commission. Earlier, the private company having paid up capital up to 1 million or less than 1 million were exempted from audit, but these criteria will also be made on a holistic basis instead of just paid up capital. So, enabling provision has been introduced in these sections. This section has also been reproduced, considering that it has more value to us. now it will now cater for such paid up capital or such other parameters as may be notified by the commission. So it will be the concept of unaudited financial statement is reintroduced. This was introduced earlier in 2017 with a threshold of 1 million. Then in 2020 amendment, this was taken away because of the very low compliance ratio. But from now it has been from different inquiries and investigation and other uh, counterpart regulators have also advised that the filing of unaudited financial statements needs to be there. And with the comparative study of the jurisdiction also suggests that there can be there should be a requirement of submission of unaudited financial statement or information to the commission as a appropriate regulatory tool. And this has been reintroduced, but it will be on a holistic basis and holistic criteria based on different parameters. Next slide, please. So these were the major amendments. I had earlier an idea to go through provision by provision, which was actually not possible. I would like to open the forum right now. If you can raise your concern, questions, so that we can note and discuss on the presentation. Back to Imran Sahab to further lead the session. Thank you, sir.
Yeah, so Shizad Sahab, we have received certain questions in the chat box. You know, so the first question is there a provision for holding virtual meeting applicable to listed companies as well? So yes, I think this has already been done.
Yes.
So could you please explain that?
Yes, if we can move to the concept paper and show the exact provision. Yes, you can. Imran sir, my screen, you can see the screen where the
Yes, yes, yes,
amendments and the
yes.
provision has been made. So this is targeting towards digitalization and ease of doing business. We have started the provision. A company may hold a general meeting at a physical venue or by using virtual meeting technology through service provider in the manner prescribed. So, and both they can have, now they can have a, we understand that in case of listed company, there may be a requirement by the shareholders that no, you hold one physical and hold. They can have now a hybrid model as well. They can entirely go on the virtual meeting. They can have entire physical meeting, or they can have both ways, a hybrid meeting, a physical and a virtual meeting. The of course, the manners is already prescribed. We have already, in case of listed company, when they want to hold the service providers are appointed, and then the votings are counted, and all these mechanism is already in place for the listed company. So it will be now it will also go forward for a private company as well with a modified model, of course. But the here we have only created the enabling provision that you can do this, you can do one mode, physical, the virtual, as well as both, whatever is possible.
Okay, we
So,
have few more questions. Few more questions as well. So the question is that in section 233A, the timeline is defined. However, the
yes.
words within such time prescribed by the commission seems super. I think there needs to be some explanation for that.
Who share anything? Okay, noted.
Okay, similarly,
Actually, for the commission, we have kept it open, but the suggestion has been noted. We'll consider that, and I would request Imran Sahab, you can also compile the feedback and forward it to SECP based on these suggestions also.
yeah, whatever
Yeah.
we are receiving, this is being recorded and we will be. So one more comment is, it is proposed that charging of markup under provisions of Section 11099 should not be applicable for private limited companies as it was under the Companies Ordinance 1984 and will ease doing business for group of companies.
So can you come again, sir? What is the question? I can't.
It is proposed that charging of markup under provisions of Section 199 should not be applicable for private limited companies as it was under the Companies Ordinance 1984 and will
Yes,
ease doing business for group of companies.
yes,
Yeah.
we have already catered this in Section 199. The exemption was only available in the Companies Act of 2017. The exemption was only limited to subsection 1. Now, if you see the subsection 3, it has not been limited to section 1, but will be the exemption will be applicable holistically on the entire section. So this has been catered.
Okay. One more question is, can you please enlighten over electronic proxy? What is the mechanism for this?
Okay, so electronic proxy means that the companies will be required to receive, as of today, they are receiving the time period is 48 days and they are required to submit those proxies to the companies. The electronic proxies can be done through now I can only version that how we have just stated as may be notified, but obviously it can be email, it can be a portal created by the company for a shareholder, or whatever the mechanism of electronic means available, WhatsApp or other means through which they can or dedicated SMS or something like that, which can be done through electronic mode, which will be a designated mode to be established by the companies, provided to the shareholders for submission of such electronic proxies.
Okay, one more question is, have the procedures for passing of a BOD resolution changed in the light of AGM, UGM exemption?
Uh, not yet. We have not changed the procedure for the BOD resolution, but it can always be that if the board is not competent, if the board itself decides not to hold that meeting, they can always have a provision to go and hold the general meetings if the board becomes incompetent. For example, there is an agenda in the board of directors where there are interested directors present, and the quorum of board is not met. Then they have to take the matter to the general meeting because there is no concept of interest in the general meeting. So in these parameters, I think sufficient provisions are already placed in, and we have our target to change this amendment uh, was to provide benefit to the companies to done away with additional procedures which they are required to done, but no such chain in prescribed procedure of POD resolutions.
Okay, there's one more question. Need clarity on time period of elected directors for listed companies as amendments are being proposed regarding election of directors of private companies.
Yes, the only change is pertinent to the private companies. The changes are only targeting towards the private companies where we have observed from the registry that the shareholders are actually the directors, and there is no difference between shareholder and directors of the company. In case of listed company, the procedure has not been changed at all.
Sorry. Uh, one more question is when will the criteria for non-audit be published by SECP, be enacted by SECP?
When the company is exempt from filing annual return. I couldn't get Imran bhai. What is the question?
When the criteria of exemption from audit will be notified?
Of course, after the promulgation of the changes, the when the National Assembly passes, the process involves that the when a bill become enactment, the amendments are approved by the National Assembly. First, the cabinet, the National Assembly, and then the Senate, and signed by the president. It will become effective. Once they are effective, applicable, like we took in May 2017, the Companies Act was enacted, and we brought in the new regulations within the period of 1 year. So it will be very swift this time, because there are less provision what the Companies Act were there. I think within the period of 3 to 6 months, all the regulations will be in place.
Okay. One more question is, can you please, uh, what about the recommendation to extend period of holding AGM for private companies from 120 days to 180 days?
Since it has been now an electronic era, and the more accounts are prepared online, so this has not been considered when the prepositions were made, and of course, for unaudited accounts, the period is uh, should not be much, but uh, the time period for such or the audited submission of audited financial statement has not been touched upon. We had discussed this with the during the meeting of National Council of ICAP, and when we will receive your comments in writing, that can be put before the decision makers, that this is one of the comments we have received, and that comment can be catered.
Okay, there is one more question, rather a comment. I would suggest that for ease of doing business, the filing and reporting requirements for private companies, which are family businesses, need to be reviewed and reduced as well.
Noted. Ji.
And there is a question regarding the amendments in previously issued financial statements. If a company finds out an error or change in accounting policy, as per IS 8, will this option be no more automatically available to listed companies? This is actually an accounting question. So, obviously, I mean, well, you'll be correcting the error, for example, and if it is a prior period error, if it is significant material, then you will be accounting for that change also in your current period financial statements. And besides that, you will be correcting, because I mean, if you change the previous year's financial statements, so consequently you will be required to change the financial statements of coming years as well, because I mean those will not, the comparatives will be required to be changed. So
Okay,
obviously,
the provision specifically says that if there is a conflict between if the directors find out a contradiction to the Companies Act, of their financial statement. So IS 8 is already there, and Commission has notified the IS 8. If there is any other thing which requires the revision in the financial statements, if it is within the parameters of the international accounting standards, the my interpretation is that that would not attract the revision of these financial statements. In the current year financial statement, if you have revised the previous year in accordance with IS8, then it's all right. But if you have submitted an financial statement for 2025, you want to change, and after 3 months you figure out that there is some change in the required in that cutoff period, now you can submit a revised financial statements. We have seen many cases. We have been that we have omitted this, and we could not take a whole account that into our system. So this is a revision of the same financial period. This remains an interpretation, but thank you for putting it up to make it more clear. We can improve the language, and if ICAP can also help us with this improvement in the language, that the intent is that if the company have made financial statement which are not in compliance with provision of this act, and if any proviso is required further, I believe you can share that with ICAP, and ICAP can share the same with us. But this is a replica of a provision made by India. So I believe, and they also have a very good sense of drafting of the act, as we have been following them since long after 1984 and 2017 and these amendments. But still, if there is ambiguity, which has just come in front of us through this message, if there is any further clarity required in this section, I propose that ICAP may please provide us in writing.
Yes, we are working. We will submit your comments shortly, and this is where you need to look at as to how things actually work. Because the law presently, the proposed amendment, allows you to make changes in the last 3 financial years financial statements. So when you make the changes in the financial statements, obviously it would require changes in the comparatives as well of the financial statements that follow of the subsequent years. So we'll be discussing it with you as well while we submit our proposed amendments. So one more question is, when the company is exempt from filing the annual return, private company having paid up capital up to 3 million and SMCs having paid up capital less than 1 million. In case there is no change of particulars since the last annual return has been filed, then why these companies are compelled to file the annual return till the last day of calendar year?
Yeah, yes. Actually, this has been a area of trouble. So, it has been the requirement we also have been facing on the information to remain updated in the registry. So we have many companies which remain dormant and do not, after incorporation, do not even come to commission or for and commission has no view. Otherwise, the supervisory mechanism in another form has to be levied. So this is the form in which the commission can see. This remains a tool that the information available with the commission is updated and is in line with the earlier submissions made by the company. So this is the logic behind doing away with this exemption, especially what we have noted in many cases where small size companies have been involved in many money laundering cases, and other cases, and they remain dormant in the registry for longest of the period. So in order to cater these these kind of circumstances, the annual returns have been made mandatory for the companies having different parameters.
Okay, there is one more comment in Companies Ordinance 1994. There was a concept of qualifying shares for directors. Can you please clarify this concept specifically with respect to SMC? What if SMC wants to appoint executive directors?
Yes, they always have this. If any director is in whole-time employment of the company, then the qualifying share criteria do not is not applied on such directors. This remains the criteria of ineligibility of director. Section 153 contains it, and it says that one has to be a member to become director, but there is a proviso to this, and proviso says that if somebody is a whole-time director, such whole-time director is not required. Similarly, a nominee director of a body corporate is not required to hold any qualifying shares. So this has already been catered in the Act.
Okay, there is a question, will there be any changes in the powers and functions of the board after the proposed amendments, which allows the board to pass general meeting resolutions in its meetings?
So see, of course, the powers have been, will, in essence, the powers have been amended, but that is subject to one thing. The powers which are to be exercised by the general meeting is to be exercised by the general meeting. However, if such decision is done by a board which holds more than 75% voting rights, then that board can decide the decisions which are to be taken in the general meeting. So it is not taking away, but making a competency of a board to pass such resolutions. And with this provision, it will be easier for companies to make quick decision making instead of going, because the board members are there. They are the one who's going to vote again in the general meeting. So if they will then be if they will be there in the general meeting, then it will be a futile exercise. They have already done it in their board meeting. Now they are also approving the same thing in the general meeting, and the essence is that it is a futile exercise. So considering that the powers have been the exemptions have been given for such kind of transaction where the board is competent to decide, be it in the general meeting or the board of directors meeting.
Okay, one more comment. The proposed amendment appears to be inconsistent with Section 135 of the Companies Act 2017. For a private or unlisted company where the quorum for a general meeting is fixed at 2 members, it is not feasible for the majority required to pass the resolution to be there to be
सर
three-fourths of the
अगर
members
सेक्शन
present.
42 काशिफ के पास होता है सर, अगर उससे पता कर ले, मैं भी अपने पार्ट पे पता कर लेता हूँ। जी
Yes,
सर,
sir. One comment is, the proposed amendment appears to be inconsistent with Section 135 of the Companies Act 2017. For a private or unlisted public company where the quorum for a general meeting is fixed at 2 members, it is not feasible for the majority required to pass the resolution to be three-fourths of the members present, as this exceeds the quorum.
For a private where the quorum for general meeting is fixed at 2 members.
Yeah.
Okay, so also see these the essence is that the voting has to be done. The decisions are to be done through voting. So all the as all the rest of the things actually become irrelevant in terms of the quorum or number of people present. It is just the majority voting rights which are going to pass a resolution. And all other criteria are actually hindrance to this philosophy of democracy. Nevertheless, we have noted the comment. We'll discuss that in detail, and we'll see if there is any contradiction that would be removed.
Okay. One more suggestion question. Can you further simplify and streamline fourth and fifth schedule with upcoming standards? Can the additional requirements of these schedules be simplified?
Uh, uh,
This is about
so,
disclosure requirements.
Can you come one more suggestion? Can we further simplify and streamline fourth and fifth schedule? Of course, the fourth and fifth schedule will be streamlined along with all the subsidiary regulations which are to be enacted once the law will be passed.
Okay. And where company with less threshold does not require audit, how can it provide audited accounts to FPR with tax return?
Okay, so FBR has an independent requirement under the income tax ordinance. So that requirement is to be complied by the company in terms of income tax ordinance, not in terms of the Companies Act 27.
Okay, on substantially operating sector, I mean, the term has been used on page 23 of concept paper. So, is it defined term?
Yes, it is. It is defined term. It is just like what used to be principal line. It is almost on the same criteria that the where the assets are deployed or the revenues are coming from that stream. That this provision is provided in an explanation to the sub provision 2 of section 1 of the section.
Actually, Shazad, there is an ambiguity because substantial means large, major. You know, they can be a company which has, but substantial term, you know, in terms of in quantitative terms, I mean, what can be substantial can be a judgmental thing for different, you know, readers or preparers. Because what is substantial and what is material, you know, for some guys, you know, 20% is material. They may be case there are three companies working in three sectors or three segments. Everyone is material, you know, at 20% each. So what is substantial need to be explained properly.
So we have made two major things in this section. One is the word substantially operating sector, and the other thing which we have introduced is it's not contrary to the concept of previously the term for the name the term was for this also actually the major problem was awarding the name with respect to principal line of business. Now earlier the concept was that it should commensurate with the name of the company. Now we have introduced the concept of that it is not in contradiction with the name of company. For example, there is a company which is Steel and Allied and working in textile sector and steel sector, and both have different segment of there. So if whichever is higher, first thing is it is substantial, and second thing is higher in substance. So that is the criteria to which it perpaid. But if further clarity is required, we are open to any suggestion by the ICAP, and we can further elaborate it if you think, if any, and we can deliberate it as well. Once we receive your final comments, we can deliberate them as well, how it will operate.
Okay. Do we have a specific definition for Waqf management company?
Yes. Now, it is just like an asset management company, but with Islamic mode, which is the Waqf, registered by the Waqf authorities. So, the Waqf management company is a complete concept, has been introduced here, uh, and the uh, and the enabling provision is provided therein, which will which will further elaborate the procedures and criteria how it will operate.
Okay. One more uh, comment is revision of financial statements for the last 3 years. Why 3 years? Revision normally is more relevant to the latest financial statements, as no one will be looking at the older financial statements at that time. Can you please guide about its rationale?
No, no, it's not that there. It is 3 years. We are saying that it is a limitation that no one can go revising financial statement prior to 3 years. It is just for the latest. That is, you have the ability to do it for the last year, the previous to last year, and previous to last year. But beyond that, you cannot go. It's in this way. The comments is actually supporting the idea.
So the comment is about, it's about why last 3 years. It seems as if I let's say if I'm sitting in 2007, 27, and I have 3 years window, so I can revise any of the 3 years financial statement. It seems from reading of the proposed provision.
Yes, if you go on to read the comment, they will say, as no one will be looking at the older financials at that time, can you please guide about this? Its rationale. So our rationale is that that 3 years are actually the latest years, the latest preceding financial years, up till which you can make any if you find out there was any wrongdoing or any non-compliance with the provision of the act, only then you can revise. But the second threshold of revision is that you cannot go beyond 3 years, because that period has already been lapsed, and nobody's interested in 5 or 7 year long financial statement to be revised again. So this is the rationale. And in terms of numbers, you see, we have made a lot of research on thresholds and numbers. Whenever there's a threshold of 10%, 25%, or whatever the percentage given in any kind of provision, which enables a right of any or infringe the right of any shareholder or member, it is always a matter of discretion during the debates. There has been a long study on by when New Zealand was making their act. They actually wanted to figure out that from where these percentages comes, and they figured out that no, there is no rationale behind the percentages which are defined or described in any of the law across the globe in terms of Companies Act. And whenever these are done through discussion and debates during between the people who are responsible and during the stakeholder considerations. So there is one rationale for three preceding financial year, another for five, another for one. So this can be, where the consensus can be reached among the people who are deliberating on it. And if we have proposed three here, during the National Assembly sessions or later sessions, these 3 years can be altered, and you can always propose that which is more relevant and with the rationale that what is being done. Here, the concept is same, that at least three preceding financial years should be allowed and not more than that.
Okay, what I'm foreseeing is that, I mean, there are, let's say, there are comments which I think require attention of the SECP team. So, I mean, I think we already had circulated the proposed amendments to our members, requiring them to provide comments. And the deadline for the comments has already passed. It was till 10th of March. So I think, I mean, if there are comments which even after clarification provided by Shahzad Saab, they may provide their comments to us, and we may consider them to while providing our comments to SSCP team. Similarly, I mean, if any of the members have any comments, which require attention of SSCP, they may also directly, I think, if SSCP team allows, they may submit their comments to SSCP team as well. Shahzad sir, what you would like? You would like to say something on this?
I think Imran sahab, it would be appropriate that the comments come to ICAP, and ICAP may compile all those comments and forward it to us. That would be more meaningful.
Okay, okay. So if any of the members, I mean, even after this session, I mean, if they have any ambiguities or any, comments, so they may submit, to us, on our previously, notified email address, which we earlier, stated in our communication. So we will consider those comments while submitting our comments to SSCP. So let's.
Sorry, Shahzad Sahab, I think there should be some time for submission of additional comments or explanations if the ICAP wish. Shahzad Sahab,
Ji, Mubasha.
I think we should fix some time for receiving receipt of comments from ICAP if they wish to.
ICAP has already, sir, ICAP has already given a time of March 17. They have
Yeah.
requested us that they will be submitting these by March 17.
Okay.
So
Okay.
any members, I mean, if they want to submit their comments to us, they may submit their comments by tomorrow. We will consider them while forming and submitting our comments to SCCPT. So we earlier, gave the time limit till 10th of March. So now today is 11th. So if any comments, any question remains unanswered, during this session, they may submit their comments on the same email address by tomorrow, and we will consider them while submitting our comments to SCCPT. So let's take few further questions, which are here, and so will the provision of audit still apply for revision financial statement? If yes, should the time limit be introduced to help auditors maintain their audit file assemblies accordingly?
Imran sir, this remains a suggestion. If there is any question, I mean, we can respond to that. Suggestions we will note and see what can be done about the suggestions.
Yeah, so this is the question. Will the provision of audit still apply for revision of financial statements? If yes, should a time limit be introduced to help auditors maintain their audit file assemblies accordingly?
Actually, I can't get hold of the question. I can't see it actually on the screen. It's
It's in question answer box.
yes. Can the timeline be fixed by first week, or can we guess?
No, that's about submission.
Okay.
Will the provisions of audit still apply for revision of file? This is in the question and answers box. The comment is, will the provisions of audit still apply for revision of financial statements? If yes, should a time limit be introduced to help auditors maintain their audit file assemblies accordingly?
So one part is the question, the other part is the suggestion. So of course, yes, of course, the revision will always be in accordance with the international accounting standards and will always be audited in terms of the auditing standards.
Okay. One more question is, can the period of laying down financial statements for private companies be increased from 120 days?
It's a suggestion, we can consider that. आज जी जी आ जाए आ जाए बात सुनिए मुझे आप
One more question is, in many cases, companies also obtain private loans from individuals or other private companies through formal agreements. However, the Companies Act places certain restrictions on such borrowings. Given that this practice is quite common in the market, has SCP provided any specific guidance or framework to regulate or accommodate such arrangements?
Yes, actually, it becomes a deposit-taking activity. No one can do the function of financial institution unless it has a license to operate as a financial institution, and this definitely falls beyond the scope of a normal private limited company. They cannot do that, and it's a violation of Section 84 of the act. So this has already been there. We act on. We have our own cell where people are attracting funds that or acting as financial institution. So nothing. I mean, if there's any wrongdoing find out by any auditor or by any member of the institute, they can always whistleblow to the SECP, and that can be catered with according to the act.
Okay. Okay. There is a comment, or there is a, let's say, a question. I mean, what if the revision of financial statements not accepted by FPR?
See, the income tax return is entirely a different matter, and Companies Act provides the procedures and practices which are available here. Once any such amendment is catered here, uh, then of course the modality with other regulator can be discussed. We have to see that how the acts unveils, and then there is a concept of revised income tax return. So, I mean, if that needs to be aligned, a further collaboration of SCCP with FPR is required. That can be done once the provision is available with us.
Okay, one more question is, when many businesses incorporate companies with a relatively small pad of capital, such as rupees 50,000, rupees 1 lakh, and later introduce a substantial amount as loans from directors or shareholders, for example, around rupees 10 million. In many cases, these companies also generate annual revenues in the range of, let's say, rupees 50 million to rupees 100 million. Is there any restriction or regulatory concern from SCCP regarding such structures?
Yes, and that is why we are now broad basing our criteria for exemptions and other things. And we are taking into account the other parameters, which includes the asset base, the turnover of the company, the number of employees it is holding. So it will be beyond the paid up capital, and the thresholds will be given on different parameters as well. Wherever we have skipped it, we also have received other comments where we have just mentioned the other parameters, and we have received one comment from BOI again that it should be that the whatever the and in fact IMF also have identified this in their comment. IMF have just provided us comments yesterday, and they have also noted this thing that you have just mentioned the parameters, but not given specifics of those parameters. So in the proposed bill, we will be proposing these measures which already have been there in our third third schedule or the fourth schedule. That is the number of employees, the total asset, or the turnover of that.
Okay. One comment is certain government and defense sector companies have been classified as PICs. However, there has been challenge related to implementation of various sections of the Act. For example, in case of Section 199, approval for related party transactions is granted by relevant ministry or defense organization head instead of BOD, and no interest is charged. There are other many challenges, while implementing the Act or on such PICs. The matter should be comprehensively looked at.
Yes, we have just discussed that at 199, the problem was with the exemption of 199 was limited to approval of the resolution and was pertaining to subsection 1 only. But now the exemption is granted uh, to the entire section where the subsection 2 talks about the interest. So this has been catered now where whenever there will be exemption, for example, the 199 is totally exempt for a private limited company. So the exemption will hold good for the entire section. The subsection 2 will not be eliminated from the exemption criteria.
Okay. Okay, there is a comment regarding changes in the audit format, audit report format. So we'll be looking at that as well. After these amendments are enacted, we'll be looking at as to what changes will be required in the audit report format in regard to revision of the financial statements. And one suggestion is for the SECP team. A dedicated tab should be created on the website of the Securities and Exchange Commission of Pakistan, where all notifications and referred to in the Companies Act are prominently displayed. Furthermore, in the Companies Act, the phrase notified by the Commission should be clarified or reconsidered, as the finding the related notification may take time in matters that are urgent and necessary.
Noted. Ji. Well, and SCCP website is under construction. The new website will come, and these ideas have already been proposed to them. There will be a complete register of regulations. That the act will come first, the regulation will come later, the notification circular. As per the act, they will be the website will be designed in accordance with with the suggestion. We are already working on this.
Okay. One question is regarding page 197 of the concept paper, section 246C. As it applies to all the companies, is there any time limit like 3 years or so if the audit period, if the audit period ended?
So, is this part of the concept paper?
Seems, I mean, section 246C. Yes.
Let me go get hold of the section. So this is regarding design and
I think
implementation.
what she's talking about, maybe, and perhaps if the audit has been carried out and the auditor, let's say 3 years have ended since the time the audit period ended. So will that audit firm be able to carry out these services or not? There should be a cooling off period.
Okay.
Let's say I'm an auditor of a company. I rendered audit services, and after that I'm no more an auditor. I think what I get from a question and 3 years have ended. So will I be able to perform these services for that company or not? Perhaps.
Yes, that's a tricky question. That whether the service was provided 3 years earlier, or whether the service is provided 3 years later. So both scenario need to be catered, but it is only applicable to the auditor of a company. If during the appointment as auditor, they cannot render their services. So the earlier or later will definitely, a further explanation will be given. The earlier or later will come into play. As far as if you point out at this point in time, if you read this, I don't think the concept of earlier or later come into play right now. If you are the auditor, you cannot provide these services. If you are not the auditor, then you can. Then there is no bar, as time period is not mentioned in the section.
Okay, let's say if I'm an auditor of a company and for this year, and let's say for 3 years, for last 3 years, I was not the auditor. Okay, and let's say if I'm required to perform any service for the last 3 years, or let's say for the forthcoming years, of which I'm not an auditor. So there may be certain scenarios I think which need to be
Yes.
thought of
And
and
Imran sir,
considered. Yeah.
you do not want me to interpret right now the law, so I think we hold this discussion for this point in time. But I mean, the plain reading of the law suggests that if you are an auditor, you cannot render the certain services. When you are not an auditor of this company in the subsequent year or in the previous year, I mean, the section will not come into play actually.
Okay, but
So,
this to be clear, I mean, as per, I mean, in the provision, you know, otherwise, I mean, there will remain an ambiguity in the and the people will, interpret it differently, and they may misuse it, and they may come across certain problems afterwards. They might come
yes.
face certain problems. So I think this needs to be clarified, I mean, in the provisions. So I think all the questions uh, have been addressed. There was one more suggestion regarding third schedule. The thresholds stated in the third schedule need to be looked at and revised because those were earlier, I think, notified sometime back in 2022. So that needs to be looked at as well by SECP and revised.
Okay. Because they are required to actually, the thresholds are going to, the parameters of the threshold are going to be changed. So once
Yeah.
those are changed, then the types of the companies will also be changed.
Okay. So far this has been a wonderful session, and I think we have answered almost all the questions. And Shriram Saab, would you like to give any comments, anything you would like to say?
Thank you very much, Imran Saab. Thank you for holding and moderating this session so elegantly. I am truly obliged for your really appreciable skills, and thank you for to all the participants who have been giving such important feedback. And I
Yeah.
hope to get a very concrete paper on the basis of which we can propose to the decision makers that other further amendments to these which can be
Okay.
proposed to them in this
Okay.
concept
One more
paper.
question is,
So
yeah, received just now received one more question. Section 26(1)(I) requires that the sector in which the company is substantially operating shall be mentioned in the articles of association of the company, which shall not
yes,
be in contradiction with the name of the company. We understand that this proposed amendment may create problem confusion in selection of the sector while obtaining the name of the company. Please clarify.
no, it will not. It will at present the word is the it must commensurate with the principal line of business. That has caused problem. And what we interpret now the commensurate is it's not in contradiction. Now, if I explain to you that the company is having one school under operating under its one uh, um, one sector, and then they are also doing a clothing line, a trading activity. So and they are not doing anything like manufacturing of steel. So they cannot have engineering company. They cannot have the name with the word engineering because they are not doing engineering, but they are so we are just referring that it should not contradict what you are doing. That if you are school, you may write education or whatever, but or you do not write education even, but you do not write that it's some other sector which is mentioned in our list of sectors.
Okay. The one comment is this is already in our comments regarding section 246A, that instead of giving a list of services which auditors cannot perform, a reference should be made of the IFAC Code of Ethics. So this is already in our comments. We'll be submitting them to you. I think we already discussed with SCP team on this.
Yes, this is a good idea. I think whenever IFAC will make any further changes, those
Yeah.
changes will automatically come into play.
Yeah. One more comment is a suggestion. In many business arrangements, once individual provides the full capital investment while the other contributes skills, time, and management expertise. When such a venture is later incorporated as a private limited company, how should shares be allocated to the person contributing non-cash value? Given that these contributions are intangible and difficult to quantify, it is suggested to include some appropriate basis for determining the shareholding structure.
Yes, that remains a specific area of venture capitalism. So they should, I mean, instead of addressing it in a company act, we should have a proper regulation or a complete licensing regime for such activity where the venture capitalist or venture capital uh, interact with the service provider and how they can introduce the concept of such non-cash value assets or shares to be addressed. We believe 83 already caters this, and we need a specific regulations in that regard. And we're working, and the relevant department is working on it, how to blend these uh, uh, this not only the venture capitalists but the crowdfunding and other things which are to be catered needs to be developed in terms of the financing of the companies and making the finance easier. So an entire concept is required to be introduced in terms of Section 83, enabling provision for issuance of share, otherwise than right, otherwise than cash is there. So the law do not restrict that. Otherwise than right can be issued, otherwise than cash can be issued. Now a regime is required to be introduced for these kind of activities where such non-cash values are to be treated, how these will be valued, how these uh, then will be then the measurement of such values need to be endorsed by some probably chartered accountant or a valuer, where a proper valuer regime is required to be introduced. So these are the concept, but I think the law is fully prepared and aware and the available for catering such transactions.
There is a question: has ICAP formed a committee to provide comments on that? Yes, we have a committee comprising of council members. We have already worked on that. We were waiting for the comment from our members. We extended the timeline. And still, if any member has any comments, they may submit their comments on the same email address by tomorrow. Okay, there is a question. I mean, if let's say if a company is not required to file audited accounts under the requirements of the Companies Act, so what will be the format? The or that company, I mean, will have its financial statements audited. I mean, if required under the in let's say income tax ordinance, and the report will be on the format as required by international standards in auditing. They will not be using the format as required by the under the Companies Act. So
Yes, the criteria is required to be notified, and this will be notified if unaudited financial statements are to be reported, and definitely ICAP and SECP will work together for such criteria, such prescriptions, and we have at present when we were discussing these provisions, we have in our mind was the nano financial statements. On the lines which UK has introduced for its micro companies. So it will be based on the kind of company and then the type of financial information or statements they're required to provide.
okay, there is a question: is Section 246 applicable to all companies, including unlisted companies?
Yes. Yes.
Okay. Okay. So I think we have answered almost all the questions, and now I would like to invite our Vice President, Mr. Jahazeb Amin Saab, to give his closing remarks. Over to Jahazeb Saab.
Thank you very much, Imran. Very grateful to the team SECP for arranging such an insightful session for our members. And we, as part of the governance structure of the financial discipline of the country, ICAP has its own significant role. And it is very heartening that the way ICAP and SECP are collaborating to bring best to the corporate sector of the country. So it is all for a common benefit, understanding the responsibility, and I'm very, very grateful to Mubashir Saeed sir for taking out the time and for being with us throughout the session. And Shazad, it has been a very, very impactful session in the way our members have interacted. It reflects that how much they are engaged with you and how much faith and confidence they are putting in all the effort that you are putting in to you. And my sincere gratitude to Team ICAP for arranging this webinar. We would have loved to have more sessions, but because of the Ramzan, in-person sessions are a little bit not practicable these days. Nonetheless, supporting the cause of federal government to bring the amendments and all the changes to their table at the earliest. So we thought it appropriate to reach out to you with this facility, and really grateful at how the members have participated. I've been receiving messages as well for the suggestions that our members have and certain things which they had initially asked, but today's session has explained those things to them and they are relatively settled on those points. Nonetheless, we will continue to work with the collective wisdom, with the input from our membership, and with the support of SECP. Together we can, bring the impact that a resilient economy with more than 275,000 registered companies needs. So thank you so much once again, Shazad and team. Thank you so much, Imran, and hope you all have a very good day ahead. Thank you so much. Over to you, Imran.
Thank you. So with this, we end this session, and we are really thankful to all our participants, all SSCP team members, and everyone for their contributions. Thank you. With this, we end the session. Allah Hafiz.
Allah Hafiz.